Imagine you're an in-house lawyer at a major company and you have to go to your direct report, the general counsel, the CEO, or chair of the board of directors, and tell him or her the following. Recall that we're defending a class action case in federal district court? Well, the judge concluded that I, as the in-house lawyer, violated state bar ethics rules and imposed sanctions on me and the company. I'm prohibited from practicing law in that district for at least 2 years. And after those 2 years, I can only reappear in that court after taking 5 hours of ethics courses. And a monetary sanction has been imposed against the company in the amount of $100,000. This scenario is not a hypothetical. It's based on an actual decision by a magistrate judge in the Southern District of Florida. And it was not based on conduct that was obviously unethical. As a class action defense lawyer, I'm passionate about not only helping clients achieve the best result possible on the merits when defending these cases, but also helping the in-house lawyers I'm working with avoid conversations like this one. Over the next 30 minutes, you'll learn how to avoid 5 ethical traps when defending class actions, including the trap that resulted in the sanctions I just described. We want you to avoid looking like this guy. You can receive ethics credits for this program and is intended to provide important practical advice for any in-house lawyer dealing with class actions. The 5 ethical traps we will cover deal with communications with class members or putative class members, and settlement of class actions. I'm not an ethics lawyer. I'm an attorney who defends class action cases. So while we will discuss the applicable ethical rules, we will also focus on real-world practical problems and solutions. My promise to you today is that I will not raise an ethical problem that you may confront for which I do not also provide a solution. As you know, ethical rules apply to you as a member of the bar. Individual states have their own rules, so it will be important, critical, to check the rules of the state in which you are practicing regarding the issues we discuss. But there are also ABA, American Bar Association, model rules that many states follow in whole or in part, and on which we will focus today. The ABA model rules have been adopted in 50 states in some form or another. As of November 1st, 2018, California was the 50th state to join in following a form of the ABA model rules. I will also reference ABA ethics opinions, which provide guidance to lawyers about how to interpret the ABA model rules when particular scenarios arise. Such opinions are often accorded great, even dispositive weight by some disciplinary agencies or courts dealing with identical or analogous ethical questions. It's important to be aware of these ethical rules because the last place any outside counsel or in-house lawyer wants to find themselves is on the wrong side of an ethics opinion or court decision impugning their ethics. We want you to avoid having the conversation described at the outset. Now, class action poses special challenges for in-house lawyers. Often the stakes are high. A single plaintiff can allege claims on behalf of thousands of others, and with astronomical damages claims, sometimes enough to bankrupt a company. In other words, they can be bet the company cases. Almost any class action is expensive to defend, and the costs of discovery alone can be staggering. Cases like these have the attention of the highest levels of management, and they may unknowingly push you to take actions that would have you fall into an ethical trap. This is especially troublesome when the traps are not obvious and may be camouflaged by moves that would be reasonable under different circumstances or if you were not a lawyer. As I mentioned, I will focus today on communications with companies' customers and settlement negotiations because those are 2 areas especially dense with ethical traps. Let's start first with communications with your customers. Here's the scenario. Your company has been sued in a consumer class action, and the class definition covers all of the company's customers over a 4-year period. The CEO approaches you and says she wants the company's lawyers to call customers and offer to give them what's reasonable in exchange for a waiver of their claims. After all, they're the company's customers, and the company communicates with them on a regular basis about all kinds of things. And this is good customer service to make them happy. This is ethical trap number 1. If a class has already been certified, this is a problem. Why? ABA Model Rule 4.2 addresses communications with a person represented by counsel. It provides that in representing a client, a lawyer shall not communicate about the subject of the representation, in other words, the litigation, with a person the lawyer knows to be represented by another lawyer in the matter, unless that lawyer has consent of the other lawyer or is authorized to do so by law or a court order. As held by the U.S. Court of Appeals in the 11th Circuit in the Kleiner case, defense counsel has an ethical duty to refrain from discussing the litigation with members of the class as of the date of class certification. Now, why in Kleiner was the trigger date the date of class certification? Because that's the date the 11th Circuit concluded that a lawyer representing the named plaintiffs also represented the other members of the class. Some courts hold that the attorney-client relationship between plaintiff's counsel and your customers is formed even before the time period for customers to opt out of the class expires. And flipping the majority rule on its head, at least one state, Pennsylvania, holds that putative class members are deemed to be represented by counsel from the moment the case is filed until class certification is denied. Accordingly, the company's outside and in-house counsel may be prohibited from communicating with its customers about waiver of claims. In other words, prohibited from communicating about settlement of the lawsuit in which those customers are represented by counsel. You may be wondering whether it might solve the problem to have the company's customer service agents make the calls rather than counsel. You may have noticed that ABA Model Rule 4.2 addresses communications by lawyers, not other company employees with different degrees. On a related note, ABA Formal Opinion 11-461 provides that parties to a matter have the right to communicate directly with one another. A lawyer may advise a client of that right and may assist the client regarding substance of the proposed communication with the other side. The lawyer's assistance need not be prompted by a request from the client. In other words, the lawyer can initiate that idea. Such assistance may not, however, result in overreaching by the lawyer. This is a problem because what constitutes overreaching is unclear. Additionally, a lawyer may not use an intermediary, an agent or another, to communicate directly with someone represented by counsel in violation of the no contact rule. ABA Model Rule 8.4 says that it's professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct through the acts of another. Some guidance suggests that if the communication is scripted or masterminded by the lawyer, that it would be a violation. However, what constitutes scripting or masterminding the communication is also unclear, leaving this area fraught with peril. Now, I promised at the outset that I would not identify a problem without also identifying a solution. In other words, I would not tell you about an ethical trap without also providing ways you can avoid or escape it. A solution here is to communicate directly with members of the putative class, if at all, before a class is certified. While there are a few states that take a more restrictive approach, and you must of course follow the applicable state that applies to your issue, this is the ABA's approach that most states follow. The ABA has issued a formal ethics opinion that directly addresses whether you can communicate with members of the putative class before the class is certified. It's ABA Formal Ethics Opinion 7-445, and it provides that before a class action has been certified, counsel for both plaintiff and defense have interest in contacting putative members of the class. The model rules of professional conduct do not generally prohibit counsel from either the plaintiff or the defendant from communicating with persons who in the future may become members of the class. So that presents another question. If your communication with members of the putative class is prior to class certification, are you clear to proceed? The answer is yes, with qualifications. This leads us to ethical trap number 2. Obtaining something from the putative class members, for example, a release or a declaration, without advising them about the pending class action. The business people often hate this. You'll hear things like, "You mean to say that we have to advertise for plaintiffs' lawyers?" There are a number of ABA model rules that apply to your communications with putative class members, even in advance of class certification. ABA Model Rule 4.3 provides that a lawyer should not state or imply that the lawyer is disinterested in dealing on behalf of a client with a person who is not represented by counsel. And ABA Model Rule 4.1 provides that a lawyer shall not make a false statement of material fact to a third person. ABA Model Rule 8.4 provides that it's professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Additionally, Federal Rule of Civil Procedure 23 allows the court to restrict communications with the putative class under its supervisory powers. This really all boils down to, is your communication with the putative class members misleading? The case law provides guidance. In the words of the Central District of California in the Parks versus Eastwood Insurance Services case, courts routinely hold that releases are misleading when they do not permit a putative class member to fully evaluate the likelihood of his recovery through the class action. Defendants have an obligation not to conceal the difference between participating in the class action and accepting short-term payment through the claims process. Parks dealt with a company sued in multiple class actions over a crude oil spill in Santa Barbara County. The company notified the victims of the oil spill using online print advertisements stating that the company is committed to doing the right thing, including making appropriate financial reparations for any verified damages or losses directly caused by the spill. The ads encourage victims to call the claims line and visit defendants' response sites, but did not mention the pending litigation or advise victims to consult counsel before contacting the defendants. The ads gave victims the opportunities to sign settlement agreements. The first release made no reference to any pending class actions, and the second release notified claimants of the name of the class action and stated that the payee, in other words, the settling party, is informed and understands that the payee may be eligible to participate in the class action, but instead has chosen to enter into this agreement. However, it still did not advise them to consult with counsel before signing the release or explicitly notify the payee of his or her right to do so. While the court did not find an ethics violation, it did find a Rule 23 violation. It held that, and I quote, "Although the second release notifies victims that a consolidated action exists, it does not provide additional information, such as an explanation of the plaintiff's claims or the contact information of plaintiff's counsel." It held that courts routinely hold that releases are misleading where they do not permit a putative class member to fully evaluate his likelihood of recovering through the class action. Defendants have an obligation not to conceal the difference between, on the one hand, participating in the class action and on the other hand, accepting the short-term payment through the claims process. Similarly, I defended a class action case where prior counsel, before class certification, worked with the company's customer service representatives to do a phone campaign with the goal to return some or all of disputed amounts and reach settlement agreements with waivers of claims. Once the plaintiff's counsel got wind of it, they asked the court to enjoin the practice, claiming that the communications were misleading because they failed to inform customers about the uncertified class action. The court agreed. It required curative notice to be provided at the company's expense and allowed any of the customers to rescind the settlements. Ultimately, the case was settled on a class-wide basis, with the company getting very little out of its pre-certification settlement effort, other than significant little litigation expenses on a side issue and negatively coloring the court's view of the company. The best practice here is to A, provide sufficient information to allow potential class members to decide whether to accept a settlement offer, B, explain the effect of settling, and C, advise how putative class members may proceed if they choose not to settle, including participation in the class. Ideally, do this in writing so there's a clear record about the company's disclosures. In obtaining the settlement releases, another pre-certification communication that can be fraught with peril is obtaining declarations from company employees when they are also putative class members. For example, in the Kazeta case, the company's counsel met with the company's employees to obtain declarations. However, the company's counsel failed to explain that the declaration could be used in plaintiff's lawsuit to limit that employee's and others' recovery. Some employees said they felt pressure to sign, and out of the more than 100 employees at issue, only 6 did not sign a declaration. The court held that this was coercive and unethical. It ruled that defendants could no longer communicate with the putative class members, their own employees, about the lawsuit without prior court approval. The court also ordered that a curative notice be issued to the class explaining that any declarations employees provided would not be considered by the court, and that the defendants could not retaliate against their employees if they chose to cooperate with plaintiff's counsel. To help provide you with guidance, let's talk about a few examples where a company or its counsel had pre-certification communications with putative class members and were found not to have made any ethical violation or run afoul of Rule 23. In other words, these are the good cases. In the Bobrick case, it was pre-certification. Defendants' attorneys obtained declarations from some of defendants' employees. While putting the disclosures in writing best protects the interests of the company, this case illustrates that a script for oral communications can also be effective. Prior to obtaining the declarations, the attorneys read a script to the employee. It made 7 points. The first 2 points told the employees who the lawyer represented, about the lawsuit, and that a class was not yet certified. The third and fourth points told the employees how the employer planned to use the information provided in the declaration. The fifth, sixth, and seventh points told the employee about the procedure. They could review the draft declaration. The employee was not required to speak with them. There would be no retaliation if they did not speak with them, and it would not be shared with the employee's manager. In other words, points that were negated that might cause the employee to feel forced to testify in a particular way or to sign the declaration. The court held that this was not an ethics violation, nor was it abusive, coercive, or misleading under Rule 23. In fact, the court rejected the argument that the communication was misleading because it omitted the plaintiff's counsel's contact information, a neutral advertisement of plaintiff's theory of the case, or the right to speak with class counsel. Instead, the court examined the entirety of the defendant's conduct and communications and found there was no statutory rule or case law that required defense counsel to give specific information and instructions to putative class members. Now, notwithstanding that case, keep in mind that while telling the settling individual or declarant about the class action is the best practice, this will help you avoid trouble, although not every court has required it. While there is authority finding no violation where a defendant did not mention the pending class action, this is an area where the company needs to tread carefully. Let's talk about another settlement scenario. The company has been sued in a consumer class action. You believe that the class action is lawyer-driven And if you settle on an individual basis with the one plaintiff who brought the class claims, there is unlikely to be a different plaintiff to step forward to file the same lawsuit against the company. That is, unless this plaintiff's lawyer with whom you are considering settling manufactures another lawsuit. Your CEO says it's fine to settle, but instructs you to include a provision in the settlement agreement stating that this plaintiff's counsel is not, the moment he's paid to settle this action, to refile essentially the same class action lawsuit with a different plaintiff. Sounds reasonable, right? This is ethical trap number 3. A settlement agreement cannot contain a clause that the plaintiff's counsel will not again sue the company. ABA Model Rule 5.6 applies here. It provides that a lawyer shall not participate in offering or making an agreement in which a restriction on the lawyer's right to practice is part of the settlement of a client controversy. A case that addressed this model rule is Adams versus Bell South Telecommunications. This is the case I mentioned at the outset regarding the sanctions recommended against in-house counsel by the magistrate judge who investigated what transpired in connection with the settlement of the action. In Adams, it was a putative class action. The settlement offer was for a $1.5 million payment to the class, and it was discussed at the mediation that plaintiff's counsel would not again sue the company. One of defendant's outside counsel, an associate who was in the room, noted that an agreement not to sue the company again would violate ethical rules. It was then suggested that perhaps Bell South could hire plaintiff's counsel via consulting arrangement to prevent their future representation of persons against the company. That's because the plaintiff's counsel would have a conflict of interest that the company wouldn't waive. The ultimate settlement amount was $1.6 million, $100,000 more, with $120,000 of that $1.6 million identified for the consulting agreement. Again, the idea was that the consulting agreement would prevent further lawsuits because the company would be a client of the plaintiff's counsel and he could not sue his own client. The court held that this practice violated Rule 5.6. The court cited ABA Ethics Committee Formal Opinion 93-371, which outlined 3 public policy goals behind the rule. First, if such agreements were permitted, they would restrict the access of the public to lawyers who, by virtue of their background and experience, may be the very best available to represent those individuals. Second, the use of such agreements may provide clients with rewards that bear less relationship to the merits of the claims than they do the desire of the defendants to buy off the plaintiff's counsel. Third, the offering of such restrictive agreements places the plaintiff's lawyer in a situation where there's a conflict between the interests of the client and those of future clients. The court reasoned that by commingling the financial consideration of the consulting agreement with the settlement monies already offered, Bell South pitted the financial interests of plaintiff's counsel against their client's interests. This stance also gave a clear financial motive to the plaintiff's counsel to undercut their client's interests by taking as large a percentage of the settlement as they wanted in consideration for the practice restriction/consulting agreement. While the Article III District Court judge eventually found that the sanctions recommended by the magistrate judge were too harsh, I'm sure that the in-house counsel subject to the sanctions was not in the best place while the magistrate judge's recommendation was pending. And the in-house counsel was still ultimately required to complete at least 5 hours of ethics courses prior to their reappearance in the district, and they were required to provide a copy of the court's order about their ethics violation to any state bar in which they were admitted. This is, of course, still not a desirable situation, although I'm sure the in-house lawyers were relieved that the company didn't have to pay $100,000 in sanctions. Again, I promise I wouldn't raise problems without also providing solutions. And while you, of course, need to check the law in your jurisdiction, the best the company can probably do here is to have what are referred to as no present intent and no inventory clauses in the settlement agreement. We have forms that from time to time we include in settlements with appropriate customization for the particular case. But essentially, the no present intent clause contains a representation by plaintiff's counsel that he has no present intent to sue the company, and the no inventory clause basically provides the plaintiff's counsel has no inventory of other plaintiffs waiting in the wings to file the same or a similar lawsuit against the company the moment this one is resolved. Indemnity agreements for third-party claims are commonplace in corporate transactions. They allocate the risk of, when there is a third-party claim, who will be responsible for it. The CEO instructs you to include an indemnity provision in the settlement agreement with plaintiff's counsel. This is ethical trap number 4. Simply asking plaintiff's counsel to provide indemnification is an ethical violation. This rule stems from ABA Model Rule 1.7, which provides in part that a lawyer shall not represent a client if there's a significant risk that the representation of the client will be materially limited by the personal interests of the lawyer. Numerous state court ethics opinions in Arizona, Indiana, Illinois, Kansas, New York, and others have examined the issue and all concluded that it's an ethics violation for defense counsel to request and for plaintiff's counsel to agree that plaintiff's counsel will indemnify defendants for claims by third parties. The rationale for these decisions is that it could create a conflict by placing the attorney's interests at odds with his client's. Plaintiff's counsel may look to the client to provide indemnification so that he can avoid his similar obligations under the settlement agreement. The solution here is don't ask for an indemnity provision. Considering purchasing insurance to cover it if you don't already have an applicable policy, or simply take the risk of a third-party claim into account when agreeing on the settlement amount. Related to some of the issues we've been discussing, there are times when plaintiff's counsel is about to do something for their benefit and to the detriment of the class. A natural reaction as defense counsel is, it's not our issue. But this is ethical trap number 5. Not speaking up when plaintiff's counsel is abandoning their duties to the class, especially when it could cause the judge to reject final approval of a class settlement. Keep in mind your goal is settlement approval. This is what buys the company peace and resolves all the claims on a class-wide basis to put the issues raised in the lawsuit behind the company. So you want to help plaintiff's counsel avoid unwittingly or intentionally violating their ethical duties to the class in a way that could jeopardize your class settlement. Let's talk about a decision issued earlier this year out of federal district court entitled Ma versus Harmless Harvest. Harmless Harvest is a manufacturer of coconut water that was advertised as 100% organic and 100% raw. Plaintiffs alleged Harmless Harvest coconut water was sold at a premium due to these advertisements, yet they were untrue according to plaintiffs. For example, plaintiffs alleged that Harmless Harvest purchased coconuts from roadside vendors with no idea whether the coconuts were grown organically or not. The parties settled for injunctive relief and a $575,000 payment in attorney's fees, expenses, and costs, and incentive awards, which included a $20,000 incentive award for the named plaintiffs. The injunctive relief provided that defendants would no longer make the advertisements, and an independent third-party consultant would for 2 years review the accuracy of the labels. Defendants underwent the expense of mediation, settlement documentation, preliminary class approval, notice to the class, only to have the settlement rejected. The court reasoned that the settlement essentially provided for $500,000 to class counsel and a $20,000 incentive fee to be divided among the named plaintiffs, but offered injunctive relief that was worth little, if anything, to the class, because Harmless Harvest had removed the raw and 100% organic labels voluntarily before the filing of the complaint or execution of the settlement agreement. In other words, the purported injunctive relief does not require Harmless Harvest to do anything it had not already voluntarily decided to do. And there was no showing that absent the settlement agreement, it would seek to reintroduce the labels in the future. So in rejecting the settlement, the court concluded that the class was receiving nearly valueless injunctive relief in exchange for a broad release, while class counsel and class representatives were receiving the only real benefit from the settlement agreement. Of course, plaintiffs and their counsel were not paid, but also Harmless Harvest did not achieve the peace it desired because the class-wide claims remained, and it spent a bunch of money on attorney's fees and class notice with nothing to show for it. Now, this is not to say that you'll be advising plaintiffs' counsel to demand more in settlement negotiations, but counsel should be thinking through whether a settlement confers sufficient benefit to the class in light of the claims made such that the court will approve it. There are other ethical questions that will, of course, arise when litigating or settling class action cases. For example, can you ethically take plaintiff's counsel up on his or her offer to dismiss a federal court action in favor of settling in state court, where the judge may be more likely to approve a settlement? I'll leave that one unanswered in this presentation, although I will say that I'm aware of at least one federal appellate court decision that is on point and the result of which may surprise you. Suffice it to say for now that shortly after a demand letter is served or a putative class action is filed, you should work with outside counsel to map out your litigation strategy and, if applicable, settlement strategy, keeping in mind to avoid ethical traps. Your and the company's realistic litigation and settlement goals can likely be achieved if handled in the right way, even in the troublesome areas we discussed.
A few years ago, the National Law Journal published an expose entitled "GCs Forget One Detail, Their License," where they famously outed 8 general counsel of Fortune 500 companies who were not properly licensed to practice law in the states where they worked. If the journal were to run a similar story today, might your name be on that list? That would be a reputational disaster I am sure each of you very much would like to avoid. Today, I'm going to share 4 key pieces of advice for in-house counsel that should help you avoid engaging in the unauthorized practice of law. Throughout my career, both as a law firm and in-house lawyer, I've been asked to advise clients and work on matters arising throughout the United States, not just in New York and California, where I am a member of the bar. As a result, the issues raised by multi-jurisdictional practice are ones that I have researched and thought a lot about in my practice. Even if most of the work you do for your company is in your home state, chances are you're going to be asked to work on transactional or litigation matters arising in other states. For that reason, it's important to know the rules that govern multi-jurisdictional practice to make sure you always stay on the right side of those rules, because breaking them can have serious consequences. The good news is that if you spend a few minutes with me today to learn the rules and take care to follow them, you should be able to represent your company in matters arising in any U.S. state, confident that your name will not appear on a future wall of shame of in-house lawyers engaged in the unauthorized practice of law. We're going to do a couple of things today. First, we're going to talk about the legal ethics rules in some detail, which are ABA Model Rules 5.5 and 8.5. In case you're worried that studying ABA Model Rules might be a waste of time, I'm pleased to inform you that as of May 2016, Model Rules 5.5 and 8.5 have been adopted in some form or another by 44 of the 50 U.S. states plus the District of Columbia. So, if you live in any state except Alabama, Hawaii, Kansas, Mississippi, Montana, and Texas, and if you learn Model Rules 5.5 and 8.5, you'll be pretty well covered. Second, even though both California and New York are among the states that have adopted rules similar to Model Rules 5.5 and 8.5, we are going to spend some time reviewing the rules in those states in detail for 2 reasons. First, many lawyers are licensed to practice in one or both states, so it will benefit a lot of lawyers to know the specifics of what rules require of lawyers who are governed by them. Second, pursuant to Model Rule 8.5, a lawyer is not only subject to the legal ethics rules of the state in which he or she is licensed, but also in any state where the lawyer performs legal work. Because in-house lawyers often work on transactional or litigation matters arising in California and New York, those lawyers need to know the legal ethics rules that govern the practice of law in California and New York under their equivalents of Model Rules 5.5 and 8.5. Along the way, I'm going to share 4 key pieces of advice for in-house counsel that should help you avoid engaging in the unauthorized practice of law. I also summarized this advice on a cheat sheet that accompanies this program, so you can refer to it later. Before we get started, why should you care about multi-jurisdictional practice? After all, what's the worst that could happen to a lawyer who is found to have engaged in the unauthorized practice of law? Well, there are at least 3 categories of nasty consequences: reputational, legal, and ethical. We already talked about reputational consequences, being outed publicly as an unlicensed lawyer, which would be a very bad thing for you and your company. The legal consequences of the unauthorized practice of law include civil liability for you and your company for violating unauthorized practice of law statutes. A finding of unauthorized practice of law also means that your company could lose the protection of the attorney-client privilege with respect to communications between you and your company's officers, directors, and employees, and the protections generally accorded to your litigation work product. In the view of the courts that have considered these cases, the result is binary. Either you are a lawyer properly licensed to practice in the state, in which case the attorney-client privilege attaches to your communications and your litigation work product is protected, or you are not a lawyer properly licensed to practice in the state, in which case there is no privilege or work product protection. I'm sure you can imagine how unhappy your CEO, board of directors, or general counsel would be if your company had to disclose internal communications everyone thought were privileged or litigation memoranda everyone believed were protected as work product. Finally, there are the ethics consequences for you as a lawyer for having engaged in the unauthorized practice of law, which include potential state bar sanctions of a fine, suspension, and disbarment. As we will see later, in nearly all states, a lawyer now can be subject to discipline in at least 2 states, the state where he or she is licensed, and any of the states where he or she performed legal work. So the potential sanctions are multiplied by the number of states involved. In a recent example, an in-house lawyer working in Florida was sanctioned by the Ohio State Bar, the only state where the lawyer was licensed to practice law, in part for having engaged in the unauthorized practice of law in Florida. Over the next 30 minutes, we'll give you the information and guidance you need to avoid an unauthorized practice of law finding, starting with a little background. As I mentioned, 46 states and the District of Columbia have adopted ABA Model Rules 5.5 and 8.5, or similar rules. Let's take a look at what these rules provide, starting with Model Rule 5.5. Model Rule 5.5c allows a lawyer to practice outside his or her home state if the practice is both temporary and fits within one of 4 specific categories that are set out in that rule. Before we get into the specifics, it's important to recognize that for the first time in American legal practice, you have a rule that affirmatively allowed a lawyer to practice law on a temporary basis in a state where he or she is not admitted. Prior to Model Rule 5.5c, there was no such authority, and all such law practice was undertaken at the lawyer's risk. The first category set out in Rule 5.5c1 is when the out-of-state lawyer associates with a lawyer in the state who actively participates in the transactional or litigation matter. For in-house lawyers, Rule 5.5c1 thus would require you to have another in-house lawyer at your company who is a member of the bar of that state associate with you, which often is not possible, or to hire outside counsel in that state to represent your company in the matter so you can associate with those lawyers, which usually is an option, but can be inefficient if you are already represented by outside counsel in the same matter in another state. If you're cynical, the option for out-of-state lawyers to associate with in-state lawyers sounds like a lot better deal for both sets of lawyers than for you or your company. The second category in Rule 5.5c2 is limited to litigators, and it allows representation of a client in this state if the representation relates to a matter in this state in which the lawyer is authorized to appear, i.e., admitted to that court's bar or admitted for that matter pro hoc vice, or to a matter in another state in which the lawyer is authorized to appear, i.e., admitted to that court's bar or admitted for that matter pro hoc vice. While it's nice to have this rule, it doesn't give in-house litigators the right to practice law outside their home states, except when it is related to a specific litigation matter pending before a court in which they are admitted to practice. The third category in Rule 5.5c3 is also limited, for the most part, to litigators because it allows representation of a client in this state if the representation relates to a pending or potential mediation, arbitration, or other form of alternative dispute resolution located in this state or in your state. So, if you're an in-house lawyer working for a company in New York, you can appear and participate in an arbitration to be held in California without committing the unauthorized practice of law in California under the authority of California's version of Model Rule 5.5, which is California Rule of Court 9.43. The only caveat is where the state requires pro hoc vice admission to appear in the mediation or arbitration, which is likely if the mediation or arbitration is being conducted by order of a court or pursuant to a judicial referral. Under Model Rule 5.5c3, you'll need to determine if your state requires pro hoc vice admission in your case, and if it does, secure that admission before participating in the mediation or arbitration. If the mediation or arbitration is being conducted pursuant to the agreement of the parties and not a court order, it's possible nothing more is required of a lawyer in order to participate. That is the case in New York, where a lawyer can participate in a mediation or arbitration held in New York without any further limitations or requirements pursuant to New York's version of Model Rule 5.5, which is New York Rule of Court 523. That is not the case in California, which imposes some additional limitations and requirements on lawyers participating in arbitrations beyond what is set forth in Model Rule 5.5. First, under California Rule of Court 9.43, the out-of-state attorney must apply to the arbitrator for permission to appear and serve a copy of the application on all parties and the state bar. This notice requirement is similar to the notice requirement for seeking pro hoc vice admission in California state courts. Second, California Rule of Court 9.43 requires that the application to appear in the arbitration meet the standards of California Code of Civil Procedure 1282.4, which in turn requires an application include the name and address of local California admitted counsel who will be the attorney of record in the arbitration, and that the out-of-state lawyer's practice within California be only occasional. The fourth category in Model Rule 5.5c4 is a catch-all for matters related to or arising out of your practice in your state and not otherwise covered by the other categories. This category is intended to cover situations where you are working on a matter that's primarily related to your state, but it has effects in another state, and the matter doesn't fall squarely into one of the other categories we just mentioned because you're not associating with an in-state lawyer, it isn't a litigation matter, or connected to a mediation or arbitration. So that's Model Rule 5.5. Let's walk through two examples to illustrate how Model Rule 5.5 works in practice for in-house counsel. Let's say you are a California lawyer who is employed as an in-house lawyer for a company based in California that has a factory located in Nevada. Now, a dispute has arisen with a Nevada vendor. Under Model Rule 5.5c4, it generally would be okay for you to advise your company on Nevada law and Nevada dispute resolution in connection with trying to resolve the dispute with the vendor. Here, you have a California client, you have a history of prior representation of that client, and you have a lot of connection to California and not as much connection to Nevada. Before you participate in a mediation or arbitration in Nevada, you need to check to see whether Nevada requires pro hoc vice admission or has other requirements for lawyers appearing in mediations or arbitrations. Recall that California imposes some requirements, while New York imposes none, to make sure you comply with Nevada's version of Model Rule 5.5c3 if you are seeking to rely on the arbitration rule. But what if your contacts with the other state are more frequent? Recall that Rule 5.5 is about authorizing the temporary practice of law in states where you are not admitted. The commentary to that rule makes it clear that your practice of law is not temporary if you have systematic and continuous contacts with that other state, even if you are not physically present in that state. Let's say you are a New York lawyer working as an in-house lawyer for a company based in New York. You do most of your legal work on matters that arise in New York, and you provide legal advice to company officers, directors, and employees based in the company's New York headquarters. However, your company has a subsidiary based in California. From time to time, you are asked to provide advice with respect to transactional and litigation matters that involve the subsidiary and other companies with which it does business in California. You also have provided legal advice to officers and employees of the subsidiary located in California. Could this be a problem, or does Rule 5.5 have you covered? As we lawyers love to say, it depends. You don't have a physical office in California, and most of your clients, your company and its officers, directors, and employees are New York residents, which are helpful facts. But you still may have trouble claiming that you are only temporarily practicing law in California because you have systematic and continuous contacts with California, and you are routinely representing a California client, i.e. the subsidiary. Nor does the fact that you are not physically located in California mean you can't have a systematic and continuous virtual presence in California. The commentary to Rule 5.5 says that a lawyer's presence can be virtual if he or she directs substantial communications to a state for the purpose of representing clients there, which, taken together, amount to a systematic and continuous presence in that state. This brings us to the first of our 4 key pieces of advice for in-house lawyers to help you avoid the unauthorized practice of law. When in doubt, register. While Rule 5.5 probably covers you in most cases where you are performing legal work or providing legal advice on a temporary basis in matters arising in states where you are not licensed, you shouldn't rely on Rule 5.5 to authorize your legal practice in states where you are physically located or are directing a substantial portion of your legal work on a regular basis, because in these cases, your practice is not temporary. Thankfully, most states now allow in-house counsel to practice law in that state without sitting for the bar exam, requiring only that they satisfy certain requirements, register, and pay some fees. Let's continue with California as our example, since my advice to the New York lawyer in our hypothetical, who is regularly representing a California subsidiary, would be to register as an in-house counsel in California. California requires in-house counsel to pay a $1,200 fee to register, and you must register within 6 months of your commencing legal work in California, or your application might be denied. You must also pay $430 per year to renew your registration and complete 25 hours of CLE in the first year and 25 hours every 3 years thereafter. California Rule of Court 9.46, which governs the registration of in-house counsel, imposes a few additional requirements, none of which is particularly onerous. For an out-of-state lawyer to practice in California as a registered in-house counsel, you have to be a member in good standing of your state's bar. The rules allow attorneys who are bar members in good standing in one state to practice law in another state, but you can't get anywhere if you're not a good standing bar member in your home state. You also must pass a character examination by the California State Bar, and as I mentioned, fulfill CLE requirements and pay fees to the California State Bar. Some of you might be thinking to yourself, he says when in doubt register, and that registration is easy, but if I add up all these requirements, wouldn't I have to do everything a California lawyer has to do except pass the bar exam? As we lawyers never like to say, yes, period. But not having to take the bar exam in California is a huge dispensation. California has a notoriously difficult bar exam. The list of famous lawyers who failed it include U.S. Senator Kamala Harris, California Governor Jerry Brown, and former Dean of Stanford Law School Kathleen Sullivan. So the only thing worse than taking the bar is failing it, particularly for an in-house lawyer who doesn't have the excuse of just having graduated from law school. Register as an in-house counsel, pay your fees, pass the character examination, do your CLE, and count yourself lucky that you can practice law in California legally and without having to sit for the California bar. Once you're registered as an in-house lawyer in California, does that mean you can do everything a California lawyer can do? As we lawyers love to say, no. But you can do pretty much everything you need to do as an in-house lawyer, which is the whole point. California Rule of Court 9.46 imposes 2 limitations on registered in-house counsel, but it also bestows one very important benefit. The first limitation is that you may only represent your employer, including its subsidiaries and affiliates under the company's control, and you may not represent any individuals. Generally, this should not present a problem for in-house lawyers, because in most cases, your client is the company and not any individual employee, officer, or director. The second limitation is that in-house lawyers can't make any court appearances. So if you are a litigator or a general counsel who would like to appear in court, you would have to go through the normal pro hoc vice process, which may or may not be available to you. For example, in California, you may not apply for admission pro hoc vice if you are a resident of California, are regularly employed in California, or engaged in substantial business, professional, or other activities in California. 2 limitations are outweighed by one huge benefit. Registered in-house counsel can practice indefinitely in California under Rule 9.46. While you must renew your registration annually, fulfill your CLE requirements, and pay your fees, you can spend your entire career practicing as an in-house lawyer in California without ever having to sit for its truly awful bar exam. What if you're looking to go the other way? You're admitted in California, but want to register as an in-house lawyer in New York. New York's Rule of Court 522.1 governs the registration of in-house lawyers in New York and generally requires the same things and provides the same benefits to in-house lawyers as California's rules do, with just a few differences. One difference is, unlike California, New York allows in-house counsel to represent individuals as long as they are employees, officers, or directors of the lawyer's employer, and as long as the representation is in connection with matters relating to the lawyer's work for the employer. So, while New York requires registration, passing a character examination, CLE, and payment of some fees, it likewise allows in-house counsel to avoid taking the bar exam and to practice indefinitely, plus a few additional things that registered in-house lawyers in California cannot do, such as represent company officers, directors, or employees as individuals. But wait, you say, I pulled out a copy of ABA Model Rule 5.5 while half listening to your presentation, and I see that rule has a Part D that specifically talks about in-house counsel. When are you going to get to that? The answer to that, gentle viewer, is right now. Model Rule 5.5D allows lawyers admitted in a U.S. state or foreign jurisdiction and not disbarred or suspended from practice in any jurisdiction to provide legal services to the lawyer's employer or its affiliates as long as the services are not services for which the forum requires pro hoc vice admission. The reason I didn't start with Model Rule 5.5D is that, as we saw with California and New York, while both states have enacted rules similar to Model Rule 5.5D, the differences are significant enough that you need to learn those rules instead of relying on Rule 5.5D. For example, Model Rule 5.5D doesn't require registration, but California and New York both do. And in the case of California, registration within the first 6 months of providing legal services in California or your application could be denied on that basis alone. For an example that goes the other way, Texas is one of the handful of states that has not adopted a rule similar to Rule 5.5D. But Texas actually gets the same result as under Model Rule 5.5D by different means. The Texas Board of Law Examiners has issued a policy statement that in-house counsel are not required to be licensed in Texas as long as they are licensed and in good standing in another state and are in-house counsel. So while Texas does not have a Model Rule 5.5D, in-house lawyers can practice in Texas as long as they meet the same requirements as Rule 5.5D. As a result, if you're an in-house lawyer seeking to take advantage of Model Rule 5.5D, you need to look at your state's version of Rule 5.5D to see what it requires, even if you live in a state that has enacted a rule similar to Rule 5.5D. This brings us to my second key piece of advice for in-house lawyers to help you avoid the unauthorized practice of law: no free lunch. Being able to practice as an in-house lawyer outside your home state does not come without a price. And I'm not talking about the state bar fees you have to pay or the CLE requirements you have to satisfy. I'm talking about the fact that practicing law outside your home state makes you subject to the ethics rules and the disciplinary authority of the state where you are practicing, in addition to the ethics rules and disciplinary authority of your home state. This is covered by ABA Model Rule 8.5, and it is almost universally followed without modification or exception by all 46 states and the District of Columbia that have adopted Rule 8.5 or similar rules. First, Model Rule 8.5 provides that a lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. So if you are a California lawyer, you are always subject to the disciplinary authority of California, even when you are performing temporary legal services in another state pursuant to the authority granted by Model Rule 5.5, or if you are an in-house counsel registered to practice in New York under New York Rule of Court 522.1. Put another way, you can never escape the disciplinary authority of the state or states in which you are a member of the bar. Second, Model Rule 8.5 provides that a lawyer is also subject to the authority of the state bar in the state or states where your law practice occurs. For example, a California lawyer performing temporary legal services in New York for a New York client under Model Rule 5.5C1 is now subject to the jurisdiction and disciplinary authority of the New York State Bar. Because lawyers who practice in more than one state subject themselves to the ethics rules and state bar committees of each state, multi-jurisdictional practice isn't a free lunch for lawyers. My third key piece of advice for in-house lawyers to help you avoid the unauthorized practice of law is litigators beware. As a former law firm and in-house litigator, I can tell you that litigators aren't afraid of much, But we should be afraid, very afraid, when it comes to multi-jurisdictional practice, because this area is full of traps waiting to ensnare in-house litigators. Let's start with a simple case that has a clear, albeit not easy, fix. If you are an in-house litigator and you are not admitted to practice in the state where you work, you need to become a member of that state's bar. There is very little that an in-house litigator can do in his or her home state that doesn't require membership in that state's bar. For example, in California, you can't appear in court or attend a deposition if you are not admitted in California. While you could do both things if you were admitted pro hoc vice in the matter, California prohibits lawyers who live or work in California from seeking pro hoc vice admission in California state courts. You can't appear or attend a deposition in a case that is pending in California federal court either, as you cannot become a member of those courts unless you are a member of the California bar. If you are an in-house litigator, my strong advice is to become a member of the bar in the state where you live and practice, because whatever you are doing now very likely involves the unauthorized practice of law in that state. For most in-house litigators, they are admitted in their home states, but are called upon to perform legal work and give advice in connection with litigation matters arising in states where they are not admitted. In typical lawyer fashion, the answer on what to do in these cases is, it depends. And we will spend the next few minutes reviewing the ethics rules and walking through a couple of examples. We already reviewed ABA Model Rule 5.5, which affords all lawyers, including litigators, some latitude to practice law temporarily in another state. If you are planning to participate in a litigation matter in a state that has adopted Model Rule 5.5 verbatim, that would be the best place to start. But as we saw before, states like California and New York have different requirements and impose different restrictions on litigators seeking to practice law in their states, so you need to check those states' rules and not simply rely on Model Rule 5.5. Let's start with what California requires of and allows in-house litigators to do in connection with litigation matters in California. California Rule of Court 9.47 governs what out-of-state litigators can and can't do in California. Rule 9.47 contains two preliminary requirements. One is easy to satisfy, and one that could give in-house litigators trouble. The easy requirement for out-of-state litigators is that you must be a good standing member of your state's bar. You can't get very far in multi-jurisdictional practice if you are disbarred or suspended in your home state. The second requirement that could be a problem is that if you have an office outside California, you must not have a California residence or substantial business in California. As I said before, if you are an in-house litigator living and working in California, you are a California lawyer and you need to be admitted in California. Apart from these general requirements, Rule 9.47 includes another specific limitation for litigators. Your legal services must be performed in anticipation of filing a lawsuit in California or in a state in which you reasonably expect to be entitled to appear, i.e., a state where you are admitted or a court where you expect to be granted leave to appear pro hoc vice, or part of a lawsuit already pending in a state in which you are entitled to appear. The idea here is that if there's a pre-litigation going on in California and you expect that a lawsuit will be filed in California, or there's an existing lawsuit in your home state of New York, you'd be allowed under Rule 9.47 to participate in settlement negotiations or attend a deposition in California. However, once a case is filed in California, Rule 9.47 requires you to seek pro hoc vice admission so as not to supplant the existing pro hoc vice system. So, if you're actively going to participate in a lawsuit that's been filed in California, you have to go through the normal pro hoc vice process, and Rule 9.47 is not a substitute for that. This is an area where in-house lawyers doing transactional work have it much better than in-house litigators. In California, as long as you meet the requirements of good standing in another state and no office, residence, or substantial business in California, California Rule of Court 9.48 gives in-house lawyers broad latitude to perform legal work and give legal advice in connection with transactional and non-litigation matters, as long as a material aspect of the transaction or other matter takes place in your state, or the advice relates to an issue of federal law or the law of a state other than California. Let's turn our attention now to in-house litigators seeking to practice in the Empire State. Unlike California, New York has a rule of court that more closely tracks Model Rule 5.5, Rule 523. And if you are in compliance with Model Rule 5.5, you will be in compliance with New York Rule 523. Here are 3 key points to keep in mind about New York's Rule 523. First, New York does allow out-of-state lawyers to associate with a New York lawyer who actively participates in and assumes joint responsibility for the matter for the purpose of performing temporary legal services in New York. Second, New York allows out-of-state litigators to participate in a mediation, arbitration, or other ADR process, and unless that process is being conducted in connection with a New York lawsuit, no pro hoc vice admission is required. Third, like California and Model Rule 5.5, practicing in New York pursuant to Rule 523 subjects you to the disciplinary authority of the New York State Bar. This brings us very close to the end of today's program, and also to my final key piece of advice for in-house lawyers to help you avoid the unauthorized practice of law. Look before you leap. While I've given you some advice today that should help you understand the legal ethics rules that govern multi-jurisdictional practice, and made you aware of several traps for the unwary lurking in those rules, you need to look carefully at the ethics rules that apply in the state or states that are at issue for you before leaping into performing legal work in any of those states. To prove my point, let's say you are an in-house lawyer in New York who wants to give legal advice to your company in connection with a litigation matter that has been filed against your company in California State Court. Having listened to today's presentation, you know that you can only perform temporary legal services in California, and that even those temporary services impose certain limitations on what you can and cannot do, particularly when litigation matters are involved. In light of this, you decide to associate with another in-house lawyer at your company who is admitted in California, who will assume primary responsibility for the matter just to be safe. Good idea, or really bad idea? The answer is really bad idea. California has no equivalent of Model Rule 5.5c1, which is the provision that gives out-of-state lawyers the option to associate with a local lawyer. The only bases on which an in-house lawyer from New York can practice law in California are the ones set out in California Rule of Court 9.46 for registered in-house counsel and Rule of Court 9.47 for litigators. If your representation doesn't fall into one of these categories, or if you don't meet the requirements of that category, you are engaged in the unauthorized practice of law in California. Worse still, your colleague who is associating with you would be violating the ethics rules by aiding and abetting you in the unauthorized practice of law in California. So, by taking what seems like a reasonable and cautious approach to a problem, but without having taken the time to study the California rules carefully, you could subject yourself, your colleague, and your company to the reputational, legal, and ethical consequences for having engaged in the unauthorized practice of law. When multi-jurisdictional practice is concerned, always remember, when in doubt, register. No free lunch, litigators beware, and look before you leap. Let's be careful out there.